Good morning. I'm Mark Agrast, Executive Director of the Society. Our president, Catherine Amirfar, had hoped to be here to welcome you, but she's in another virtual room introducing Sir Daniel Bethlehem to deliver the Charles N. Brower Lecture, and she asked me to extend her best wishes to you all. This annual event is a cherished tradition at the Society, and we're very pleased to partner with Arnold and Porter in honoring current employees and alumni of the Office of the Legal Advisor at the Department of State. Although this year we cannot offer you the usual drinks and hors d'oeuvres, we are glad to be able to continue this tradition in a virtual format. Most of the men and women who have served as L attorneys and many of the career attorneys who have served with them have been members of the American Society of International Law, and more than a few have played an active role in our work. This annual gathering is a way of expressing our appreciation for their service to the nation and our support for a unique and vital institution. At yesterday's opening ceremony, I was pleased to announce that the Society has established an annual book award in memory of a legendary L attorney, Robert E. Dalton, who passed away this past year. As many of you know, Bob was a leading authority on the law of treaties, who served at the department for 61 years, including 36 years at L. He also was an active member of the Society for over 50 years and was loved and admired by all. The award is called the Robert E. Dalton Award for Outstanding Contribution to the Field of Foreign Relations Law, and we will present it for the first time at the next annual meeting in March 2021. If you missed our tribute to Bob that took place at yesterday's opening ceremony, you can watch it on demand. I'd like to thank Arnold and Porter for continuing its longtime sponsorship of this event, and to express my particular appreciation to John Bellinger for organizing and chairing today's program. John has long been an active member of ASIL and has served in a number of leadership roles, including as a member of our Executive Council. He heads the global law and policy practice at Arnold and Porter. He joined the firm after holding several senior presidential appointments in the U.S. government. In addition to that of legal advisor, he has been senior associate counsel to the president and legal advisor to the National Security Council. He also served as counsel for national security matters in the criminal division of the Department of Justice, as counsel to the Senate Select Committee on Intelligence, and as special assistant to Director of Central Intelligence William Webster. John, it's always great to have you with us. I'm delighted now to turn the proceedings over to you.
Mark, thanks so much. Thank you for the introduction. Thank you for putting together an extraordinary virtual annual meeting. All of us, of course, were disappointed not to be there in person, but it looks like we're off to a great virtual start. I also want to thank ASIL for organizing the book award for Bob Dalton, who was a treasured member of the Legal Advisor's Office, a great resource for me on treaties, and this is a terrific recognition for him. So thank you very much. Arnold and Porter has been honored to be able to host the annual L reception for current and former members of the Legal Advisor's Office. It was a highlight for me to attend when I was the legal advisor. It's been a highlight to sponsor it. We, of course, invite friends of L, like the two panelists who we have today. So I'm sorry that we are not able to provide the normal food and drink, but instead we will be providing food for thought. I'm joined, I think, today or often with a number of my colleagues at Arnold and Porter who are former members of the Legal Advisor's Office: Sam Whitten, Paolo De Rosa, Jeff Smith, all former members of L, as well as with Tom Shannon, the former Undersecretary of State, who's joined us at Arnold and Porter and sends his best. He spoke to you all last year. So again, we look forward to a virtual session today. So instead of being able to talk with each other, we have instead a set of distinguished panelists, all old friends and colleagues of mine. So I'm particularly excited about doing this. Let me start. We have Merrick String, who is the acting legal advisor and who wanted very much to be with us today, both to greet former members of L and friends of L, was called away. All of us as legal advisors know that happens, but I know he's very disappointed. He knows Christoph Eich quite well, and many of you all, and he sends his regrets. Instead, though, we have someone known well to all of you all, Rich Visek, who is the principal deputy legal advisor in L, has been in the office for 22 years, was there, unfortunately for him, when I was there. But Rich is a great friend and a terrific lawyer. He spent a year as the acting legal advisor in the first year of the Trump administration. Previously, he had been recognized for his services with a presidential rank award of Distinguished Executive, which is the highest award bestowed on career civil servants in the U.S. government. So, Rich, thank you for your service. Kathy Adams, another old friend of mine. Kathy is a member of the British government's Foreign Office, Legal Advisor's Office, was in the Foreign Office when I was at L. She moved to the Attorney General's office in the UK and then became the legal advisor for the then newly and briefly formed Department for Exiting the EU, the department in charge of the exit, the Brexit. And then for her sins, since she was successful at doing that, has now been put in charge of all of the negotiations on behalf of Number 10 Downing Street for renegotiating all of the agreements between the UK and the EU, something that I think will be interesting to all of us. Finally, another old friend who's probably heard me talk way too much when I was legal advisor on issues of detainees and terrorism. Christoph Eich, Ambassador Christoph Eich, is the Director General for Legal Affairs of the German Foreign Ministry and has been for the last 3 years. He had previously been the Deputy Chief of Mission and Chargé d'Affaires for the German Embassy in Beijing. And then prior to that had spent many years, I think 5 years, in New York as a senior German diplomat at the German mission to the UN. So welcome to all of you, all old friends. I should also mention, for those of you who know Kathy, Kathy had the singular honor earlier this year of being recognized and awarded by the Queen with the Order of St. Michael and St. George for her contributions to international law, which is really an extraordinary thing. So Kathy, congratulations to you all. I am going to ask questions for the group for about 35 minutes or so, and then we'll be opening it up for questions from all of you all. To do this efficiently, if you all will be sending in questions to me by the chat function, and then I will put them to our panelists. So please feel free to send in your questions. So with that, Chris, let me start with sort of a lightning round, because this is an unusual time of trying to manage both government legal offices, but also for those of us in the international business to be doing international negotiations, which are normally done face-to-face during a time of coronavirus. So let me just start by asking each of you, how are you actually managing your staffs? Are you coming into the office yourselves? Are they coming in? Are you in Zoom meetings internally all day long? And then, since what we do is international law, are you talking to your colleagues with negotiations by Zoom and getting things done in that way? So, Rich, why don't we start with you?
Thank you, John. And first, I want to thank the Society and Arnold and Porter for hosting this great event. And I truly appreciate, both on a personal and on behalf of the Office of the Legal Advisor, the kind words and the award in honor of Bob Dalton, who was a dear and cherished colleague and friend. It seems so long ago, but it's really only been, probably 5.5, 6 months that we've been dealing with the COVID pandemic. Yeah, and our first sort of entry point to it was how to get our personnel and our American citizens out of Wuhan. And Elle was integrally involved in advising on that. And then, of course, we had the Diamond Princess. And then as the pandemic spread, it became very clear that all of our work was going to be affected. How we do work, what we advise on, et cetera. Like so many others, we moved to a virtual footprint, a lot of teleworking. We had issues with daycares being shut down and elder care, so we incorporated flexible work hours to accommodate our personnel. But like so many other foreign ministries, we still have the challenge of handling classified information, and you can't do that from home. So we go in every few days, and everybody's on call. So we try to meet those needs as best we can. In addition to the logistical challenges, I would just say that COVID has also turned out to be a major work generator, if you will. We are a core general counsel shop, both international, but also supporting the operational platform of the department. So probably by now, I would say almost virtually all of the 23 constituent legal offices in the Office of the Legal Advisor have worked on COVID issues. And we have what I would call a virtual coronavirus working group of about 40 plus attorneys that is fully engaged on COVID-related issues. And just to quickly give you sort of a flavor, we have spent a lot of time advising on repatriations and medical evacuations. The department has repatriated over 105,000 Americans back to the United States on over 1,100 flights from over 130 countries. So it's kind of like a mini or maybe a comparable Dunkirk type operation, if you will, in the face of the pandemic. And we've had attorneys advising all of these issues, consular attorneys advising on overseas citizen travel issues, appropriations, medical issues, you name it. Then we've also had the usual, sort of COVID has created issues for us in diplomatic law. When do you test? And when foreign governments want to test your diplomats coming back to country, how do you feel about that? We have foreign assistance issues and obviously international health issues. So it's been pretty eye-opening just in terms of all the new work that the pandemic has generated. And then the old work has continued, strangely, and sort of, and almost just as busily, minus preparing for in-person meetings. I'd note that, for example, with NASA's Artemis program, many of you may have seen the space launch on May 30th, and they're going back to the moon with an eye towards using it for research and study to move beyond the moon. We have been negotiating. In fact, we just finished a negotiation, and the European Space Agency just approved an MOU with the United States to provide for cooperation for a lunar gateway that will orbit around the moon and support lunar activities. And that's part of a series of arrangements that we've been negotiating this year to support the Gateway Project, which is the name given to the orbiting lunar module. And then we continue to try to operate virtually in the negotiations in multilateral fora. We just had a meeting with the North Atlantic Salmon Conservation Organization that went over the course of several days using video conferences. So that work continues. And then in various other international fora, we're doing our level best. We've found to some extent that there's challenges associated with it, not the least of which is time zones for larger meetings with multiple participants. But I would say at the end of the day that as tragic as the circumstances have been, and obviously nobody wants to have another pandemic, and we'd like to see this one end as soon as possible. we have learned some valuable lessons on how to do our work. And I think going forward, a lot of the things that we're doing now, whether it be teleworking, whether it be more flexibilities, whether it be new ways of meeting that are very cost effective, I think we're going to carry those forward with us in the coming years. At least as long as I'm here, we will carry those forward with us in the coming years. Thank you, John.
Well, thanks, Rich. Glad to hear the work is continuing, even with the challenges. Kathy, your whole job is doing international negotiations. So you've got not only internal staffing, but you have to be talking to other countries. So how's that all working?
Sure. Thanks, John, and thanks for your kind words of introduction. As you say, my team is focused on the negotiations with the EU of our future relationship, but also implementing. Half of my team is implementing the withdrawal agreement. Although we've concluded that and it's in force, there is quite a lot of work still to be done in implementation of it. And all of this obviously involves engagement with our colleagues in Brussels. I'm happy to say we've been somewhat insulated from on the substantive work side from a lot of the COVID work. I mean, a lot of the issues that Rich was just describing obviously have also arisen across the UK government, and there's been a lot of moving people around, moving the chess pieces around to sort of to focus on the COVID response. I have a relatively small team. There's about 40 lawyers at the moment. So, I mean, happily for me, they've recognised that we have enough on our plate without dealing with the specifics of COVID. But it has obviously, I mean, we went into semi-lockdown on the 16th of March and then a full lockdown on the 23rd of March. And since that time, pretty much the whole team have been working remotely most of the time. I think I went into the office for the first time the beginning of June and have been in maybe 4 or 5 times since. So we're kind of all, like so many people, you're getting used to that whole, new ways of working and actually trying to find, looking for the opportunities actually in the enforced sort of ways that we have to work, actually looking for the opportunities to improve our ways of working. And it's actually prompted a discussion across the UK government about things like, well, does the government need to be in London? Should we be reaching out to sort of the regions and relocating people around the place, and a sort of a more fitting in with the government sort of levelling up agenda. So that's a sort of big part. There's a big chunk of work around just, as you say, making sure we function and making sure the team functions and making sure, no one is kind of left behind in the team and feeling isolated. And there's a lot of discussion about morale and well-being and all of that is a big part of our conversation at the moment. In terms of the substance of the work, we agreed in I think February a sort of process of negotiation with a series of rounds of negotiation leading up to the end of June in the first instance. And we had round 1 in the first week of March, and we were just about to go into round 2. And then, of course, everybody went into lockdown. So that's sort of thrown the process somewhat off course. We have had sort of 1 round by phone and then 3 by video in the meantime. It's kind of interesting way to go. It's not the same, obviously, as being face to face. I can see, I can see you on the screen, but when you have quite a large number of people, you can't see everybody, and people, it's depending on whether people or not turn their video cameras off, and it all depends on whether anyone's home broadband is actually functioning properly on that day. Suddenly they kind of disappear, and then someone has to turn their video off, and you definitely lose something. We have been able to make some progress and have some really useful discussions, but it just isn't the same as kind of eyeballing people, across a negotiating table. And obviously you totally lose the opportunity to have those conversations in the margins. Obviously that's not possible, and the whole discussion has to be quite carefully choreographed, because you know what it's like on a Zoom meeting or something where you've got a lot of people and everyone, you can't just have everybody trying to talk at the same time. So it's a little bit more structured, I suspect, than it might otherwise be, the conversation, and you lose obviously some of the immediacy. But it's actually, I think, worked better than some people expected, I think, I would say, on that front.
Interesting. Well, I'll come back to you on the substance because I know people will want to know how it's going. I am interested that the British government may move out of London. So I'm going to say Ian MacLeod may try to move the Foreign Office, or at least the Legal Advisor's Office, up to Scotland. Christoph, how about you all? What about managing your office and then managing whatever the international work that you are doing for the Foreign Office right now?
Well, thank you, John, and it's lovely to see you and to hear you. It's been a while, but it's lovely to see you, healthy and in good spirits. And I wanted to say also, it's a privilege for me to be participating on this panel. And I would like to say to Mark that I've been a member of the American Society for 30 years now, and it's a society I appreciate very much. Now, as Kathy and Rich have said, of course, we have very similar challenges. The challenge to keep people safe on the one hand, and to remain operational on the other. Now, as you know, Germany has been quite lucky, quite fortunate with the COVID. I think we have so far managed to avoid worse consequences, but still we have had lockdowns. We've had to reduce considerably our workforce at the office. We work in teams that alternate between working at home and working at the office. I've been spending, whole weeks at a time at home and then coming to the office on basically alternate weeks. Of course, it's been a challenge to to adapt to this kind of work. Diplomacy and lawyers, we like to meet face to face and to discuss face to face, and this is something that I do miss. I do miss meeting and traveling with colleagues from other countries, and I hope that we will be able to pick up again while maintaining some of the positive lessons that we have learned with working remotely. I mean, I think some of the things we will definitely want to keep for our workforce. Now, similar to Rich, we have the legal office is also responsible for consular affairs. We are responsible. My office is responsible for the consular, for the consular responsibilities that we have looking after our nationals abroad. And we've had a massive repatriation effort with 260,000 Germans that we managed to repatriate from the four corners of the globe. It was a great effort where all our missions abroad were involved, and where also a number of legal issues were raised by the way. And as far as international law issues are concerned, I think some of them were mentioned already. I would like to say that the issue of diplomatic immunities, that's one that was that actually was a very interesting one, and many issues came up that even our experts had never thought about. But I think generally speaking, there is a good amount of consensus building around the rules of the Vienna Convention and the requirements. Another issue was human rights and derogation from obligations under certain international conventions. And I would like to mention a last point, perhaps, is the issue of fighting the pandemic as a community interest. And immunization and having a vaccine as a global public good. That's something that is cropping up both in the UN and also at the European level, for instance. It's an interesting discussion also for lawyers. Sovereign interests, community interests. What does it actually mean in terms of obligations for states to provide vaccines and so on at an affordable cost? So, as an introduction, that's it for me.
That's really interesting, Christoph, and I think for probably the students who are listening, and even me, you've raised some issues that I hadn't even really thought of. You and Rich on, diplomatic immunity, on testing, derogation, some of these other issues. So lots of food for future student notes. So let me do a round on substance. And Kathy, let me start with you. And I know people are going to be very interested in this because it's not really that well covered, at least in the American papers. So what are you negotiating? Are you doing dozens, hundreds of agreements all at the same time? You must be you cannot have enough people to be negotiating every single UK-EU agreement from trade to people to Europol to the space agency. What's being negotiated? How's it being done? And are you prioritizing some over the others?
Sure. So, the whole process of withdrawal from the EU is a cross-government, obviously it's a cross-UK government effort. Our team advises David Frost, who is the Prime Minister's chief negotiator, and the focus for us is on the UK-EU negotiation of the future relationship. Just to remind people, in case they haven't been following every twist and turn of the saga, the UK, we formally left the EU on the 31st of March this year, but we're now currently in a transition period, which will last to the end of this year. The Prime Minister has, the UK government's decided doesn't wish to, there was a possibility in our withdrawal agreement to extend that, but the decision has now been taken not to do that. So we will be leaving that transition period on the 1st of January next year. The transition period is essentially a sort of slightly strange device whereby we're not in the EU, but the EU acquis, the corpus of EU law continues to apply to us. And that has some quite interesting and consequences for all these third country agreements, as we call them, agreements between the EU and its member states and third countries. And for me, actually, trying to grapple with that issue is one of the most legally actually interesting aspects of the whole Brexit process from the perspective of international law, because obviously it was not something that could just be sort of fixed between the EU and the UK, because you obviously have the rights and obligations of third countries, including, of course, the US, but many others, to take account of. So, as I say, the concept of this transition period is we're still essentially bound by the sort of body of EU law. So it kind of made sense for all these agreements to continue to apply. And indeed, under EU rules, we didn't have the right to go off and negotiate separate agreements in any event during this period. So we came up eventually with this system, as I say, which has lasted for this current year, a sort of rather delicate compromise, I think I might say, whereby we agreed in the withdrawal agreement to be bound by the obligations under all these agreements. The EU agreed that they would treat us as if we were a member state for the purposes of these agreements. And then third countries were sent a note verbal sort of setting out this arrangement. And there was a sort of not exactly there was a sort of, it was up to third countries how they responded, shall we say, to that notification, whether they chose to treat it as an invitation to agree to this arrangement or whether they were happy to acquiesce in it or indeed not to agree to it. I think, if you delve very deep into the international law treaty principles of all of that, it's not necessarily that easy to identify what exactly everybody was doing as a treaty law matter. But I think I think as a sort of guiding principle, it was helpful that most third country partners, all third country partners, were sort of there was a will to make it work. And I think that's the key thing. And I think generally speaking, it has worked. Beyond the end of this year, of course, we have to replace all those agreements with something else. Every time I used to see a list, there was a different number of how many third country agreements there were with the EU and its member states, several hundred in any event. Not all of them are going to be relevant to us for the future, but obviously many of them would be. So there was like a huge program. I mean, this started some time ago of working out how we were going to manage those. Did we need to continue? Did we want to continue to be bound by them? Did we want to conclude new agreements? How we were going to manage all of that? And there are different categories of agreement depending on whether they're bilateral or multilateral. So on the trade side, a lot of agreements were what we call sort of rolled over. There was a system of basically a sort of, if you like, a temporary agreement, or at least an agreement with the third country that from the end of the transition period, we would continue to apply essentially the same rules as under the EU agreement until such times we had time to fully negotiate a successor. Multilaterals are slightly, multilaterals, at least where the member states are party, are slightly easier to deal with, because then it's just a question of being clear at the end of the transition period that we now, as the UK, assume full competence for the whole agreement, as opposed to sharing it with the EU. EU-only agreement, and there are a small category of multilateral agreements where because it was exclusive EU competence, the EU was the only party. Those have proved somewhat more complicated to organise, but I think we have, after a lot of time and energy spent on and negotiation spent on resolving that, that seemed, we have a process in place in most of those forums to make that work. What we are negotiating with our European colleagues is, as I say, essentially a future trade agreement and then other areas of cooperation. I think that there is a whole separate round of negotiations which is run by our Department of International Trade of agreements on trade with the rest of the world other than the EU. And obviously there's a job to coordinate those two processes, but the EU negotiation is sort of centrally run by the Prime Minister's office. I think we have quite a job of work to do, I think it's fair to say, because, obviously the aim is to have this agreement in force by the 1st of January 2021, which is not very long in the future. And bearing in mind the need for ratification processes and legislative processes, this is, well, it always was challenging, and I think it's fair to say it remains challenging. But at a meeting 2 weeks ago, Prime Minister Boris Johnson met with the three presidents of the Commission and the Council and the European Parliament, and they agreed an intensification of this process of negotiation. So, having had our rounds of WebEx,
I bet that was great news for you, Kathy.
Yeah, exactly.
About the intensification.
No summer holiday for me, I think. So we are now about to go back into face-to-face negotiations, starting on Monday. With a view to trying, I think the battle lines in the negotiation are fairly well drawn and have been publicly stated. So it's no huge secret. But I think the aim of this will be to try and get an agreement on the sort of overriding principles, so we can I think there is a commitment at high political level on both sides to try and reach an agreement in time for the end of the year. So in terms of the number of agreements that I'm personally dealing with, well, I think that depends on where the negotiation comes out, because the EU proposal is to have a single agreement covering both trade and a range of other areas of cooperation, including things like air transport, nuclear cooperation, law enforcement cooperation, and other matters of that kind. Our proposal is basically to have a free trade agreement and then a series of side agreements based on sort of other EU precedents that have been concluded in the past, and that that structure is one of the issues that we will have to grapple with over the next a few weeks, and that obviously has implications for things like dispute settlement and the sort of overarching governance of the agreement, which I think, and the role of the Court of Justice, I think, is going to be one of the critical issues that we will need to resolve, because it's quite challenging. The Prime Minister set out a very clear position, going back even to Theresa May's sort of first speech on Brexit, about the jurisdiction, not accepting the jurisdiction of the Court of Justice. But from the EU perspective, I mean, we understand this quite well, but having previously been a member state, there is case law from the Court of Justice that says only the Court of Justice can be the judicial arbiter of provisions which are substantially the same as EU law. So there's a bit of a conundrum to work around how you navigate that. That issue, I think, will be one of the big questions that we have to get over. And then, in addition to many other sort of policy arguments.
More fruit for student notes. I'll come back on some of these agreements. So really interesting. You have your work cut out for you. Christoph, I want to ask you about something that I suspect fairly few people over here on our side of the pond know about, which is a international law initiative that you and the French launched last year called the Alliance for Multilateralism to promote respect for international law. And I note, I don't know whether connected or not, you can tell me whether you will connect the two of them, that the German Security Council presidency starts next week. And I wonder in particular, given the years that you spent in New York, whether there might be an international law component there to the German Security Council presidency. But tell us a little bit about what we might expect both from the alliance and also on international law from the Security Council presidency.
Well, thank you, John. Well, there's always an international law component in what the Security Council does. That's why the US and the UK and us and many others have dedicated international lawyers working in their missions. And it's important that they are involved, because many international law issues come up. But apart from that, indeed, part of our program, being a non-permanent member of the Security Council, including when we act as president, is to bring international law issues more to the fore. In particular, human rights issues and international humanitarian law issues. We'll have to see what is in store. Of course, as you know, the Security Council is struggling with meeting. I mean, they haven't met physically. In fact, as lawyers, we discovered that the Security Council has not had any formal meetings since mid-March. These have all been VTC meetings in different formats, very innovative, and there again, some things might be carried over until post-COVID times. But it is a challenge, also as far as working methods are concerned. Now, I want to say perhaps a few words on this Alliance for Multilateralism and the importance of multilateralism in German policy. You know that today is actually we're marking 75 years of the signing of the UN Charter in San Francisco, which is a great day. We have today's German newspapers quite a few articles on that event. I mean, Germany was not, of course, in San Francisco. In fact, the war was just over in Europe. It wasn't even over in other parts of the world. And I know that we appreciate, everybody here appreciates the role of the US in particular in setting this whole thing up. San Francisco Conference, and so there is a long tradition in Germany of upholding multilateralism, and we felt, and my minister very strongly felt, that with the many challenges that we have, challenges on multilateralism, that we should, get people together. It's basically, it's an alliance of the willing, if you like. It's not an international organization, or it's just, states, loose number of states, everybody who's, who wants to be participating in any of the events that we are holding with others is welcome. I mean, we had an event today, of course, via VTC on with the WHO on health issues, and what are we going to do with better meeting the challenges posed by the pandemic. So it's really it's a multilateral thing. It emphasizes international law as the DNA of multilateralism. It's about pulling together. It's about not going it alone, but looking for solutions for the complicated problems that we have in today's world.
Thanks, Christoph. And I think I'll be interested to see what Germany does during the Security Council presidency, but particularly with respect to international law issues. So, Rich, I'm going to ask you a somewhat harder one here, just because it's been on a lot of people's minds. And I know Marek was prepared to chat. So 2 weeks ago, the White House president issued this executive order imposing sanctions on the International Criminal Court and its employees, authorizing the Secretary of State to freeze the assets of court employees. And of course, that follows on to a speech that John Bolton had given about 2 years ago. So it didn't come as a complete surprise. It's obviously been controversial in many quarters, particularly internationally. And so I want to ask two questions. One, could this have been avoided? Obviously, this was triggered by the court's investigation of Afghanistan. Is there, as many international lawyers have written, including people who are friends of the court, still an off-ramp so that what looks like we already have had a head-on collision, but we can avoid a period for the foreseeable future where there is antagonism, hostility between the U.S. and the court. And frankly, many of our friends, the U.S. or the U.K., Germany, others who really do not want to get caught in the middle of all of this and might. So that question one, is there a resolution here possible? And something more than just saying, well, the court needs to drop the investigation. I mean, is there some sort of a resolution? And then second, actually a legal question for you, because they're beginning to come up. The executive order prohibits Americans from providing any support or services to the court. And that's written so broadly as to suggest that if a law professor or an advocacy organization helps the court with some investigation that the U.S. used to support, like child soldiers in Africa or Sudan, or some of the Americans who are working on the court, that they themselves would be subject to perhaps an enforcement action. But I know Elle is in the middle of all of this because the Secretary of State has given the lead authority under the executive order. So help us out here. And then I'm going to head to the audience questions in a minute.
Well, John, thank you for the question. Let me tackle the second part of the question first, if I may. The way the EO is set up, it is intended to provide for economic sanctions against designated officials, ICC officials, who were directly engaged in the ICC efforts to investigate U.S. personnel or allied personnel without the relevant state's consent. So the EAO does not automatically block the ICC itself or its member states. There is this directly engaged nexus. And it's also dependent on a designation under the EO. To date, there has not been a designation. I can't I don't have a crystal ball, so I can't preview one way or the other. But I think it is intended to be, while perhaps broadly written, it is intended to be sort of targeted and focused. In terms of an off-ramp, boy, I think the issues that have led to this obviously were ones that were discussed decades ago when the Rome Statute was negotiated. And I think the US position and the decision not to become a party was always sort of premised in the idea that we support international accountability, but we would like to be responsible for our own accountability measures with respect to our own personnel, whether it be under the Military Code of Justice, whether it be through Department of Justice prosecutions. So I think our sort of message consistently across several administrations is that while we respected the decision of other states to participate and join the court, we were also ever hoping that the court would and its members would respect our decision not to become a party to the court. And obviously this all sort of, I guess, metastasized, if you will, with the situation in Afghanistan when the Office of the Prosecutor decided to open up a preliminary examination and then ultimately proceed towards an investigation. And I don't want to get in the habit of confirming or denying whether particular communications took place, but I think it's fair to say that over the years and across administrations, the United States has been voicing its concern about the court exercising jurisdiction over US personnel without our consent. And so, yes, I think it would be very good if they would drop the investigation. I don't know that they will. Obviously, there's matters of pride and prerogatives on both sides. I would note, though, that we thought that the timing of the court's decision to authorize the investigation into the situation in Afghanistan was very unfortunate because it was announced just as it looked like the prospects for a peace in Afghanistan. We're at a tender state of negotiations and trying to make arrangements and look forward to a peaceful resolution in Afghanistan, and we did not think it was helpful. I would note that Afghanistan itself has filed a deferral submission under Article 18. So we'll see what the Office of the Prosecutor does with respect to that. My hope is that that the deferral will not be contested, and that perhaps will provide breathing space. But I think obviously this is going to be a relationship that we have to sort out. I think in the past, as you know, the United States has been supportive of various accountability efforts, including of the ICC in bringing to justice various individuals. We've also been very supportive of other accountability mechanisms, not the least of which are the international tribunals for Rwanda and the former Yugoslavia, which then obviously became the MICT. We've been supportive of the specialist chambers that are looking into Kosovo. So I think there are off-ramps. It's just a question of whether there's a willingness. I do think, however, that in the court's decision, there is something that other states, and I think there is a reform movement brewing in relationship to the ICC. There are concerns about how it approaches complementarity. I think the decision authorizing the investigation was a little troubling in that it in effect took interests of justice off the table as a topic that could be judicially reviewed. And I think had the original negotiators known that would happen, they would have been very troubled and probably would have taken steps. So I've spoken at length, but I appreciate the question, and I appreciate the views of those who disagree with our position.
Well, thanks, Rich. And I know it's a difficult issues. Of course, when I was legal advisor, I was coming on top of several years of a tense relationship between the court and the U.S. And we tried to put things on a more even keel of constructive engagement when I was legal advisor. But admittedly, that was not at the time when the court was, in fact, doing what it's doing now, which is essentially picking a fight with the United States. So it makes it difficult. And I appreciate your explaining that. These are not easy issues, but these are the sorts of issues that the legal advisor's office has to deal with one way or another. So thank you. So audience questions, we've got about 5 minutes left. And Kathy, I get a difficult one for you. Maybe not quite so much as for the ICC, but how will the UK thread the needle with the EU FTA and the FTA negotiations with the US on regulatory issues, such as on chlorinated chicken and GMOs? How do you do two things at the same time?
Well, that's a very good question. I mean, obviously, as I said in my previous answer, there has to be a lot of coordination, because it's a complex task, because we've got this EU negotiation going on, and then there's not just with the US, but also with Australia, Canada, Japan. There's a whole schedule. I mean, it's a challenging set of negotiations across government, and obviously there are interactions between them all on things like that. I think it's quite difficult for me to sort of say, obviously, what I think the answer is necessarily going to be on any of that. I mean, the government has made its, in fact, only this morning, I mean, the question of chlorinated chicken is one of quite high interest in the UK. I don't think anyone had heard of chlorinated chicken until fairly recently, but it pop up in kind of popular discourse as a thing quite a lot, and there's a lot of awareness about it. And the government has stated clearly that it doesn't intend to minimize standards. So we will. I think we will have to see how that goes. I mean, I think there's not much I can say from where I am now as to precisely what the solution on all of that is going to be. Suffice to say that the coordination mechanisms are really important to make sure that the intersection of all these negotiations comes together, which is a kind of added challenge in the time available, I think it's fair to say.
We look forward to having you back at an annual meeting next year, Kathy. So here's a question which actually should go to all of you all, but we don't have enough time. But I think this will actually be interesting to many, particularly students. But this is a question that all of us as legal advisors have to grapple with. So, Christoph, I'm going to let you handle it on behalf of all legal advisors. How does a legal advisor stay sensitive to the client's needs and still provide unsolicited, when not desired, and complete legal advice in line with your own duty? And I will tell you briefly, as you think about the answer to the question, what I told Elle when I was legal advisor, because there was always sort of a suspicion amongst conservatives, and of course we were in the Bush administration, that lawyers in the legal advisor's office would shade their legal advice to provide a policy solution. And I would say, look, your clients will respect you if you start with the legal answer, tell them what it is that they want to do as a legal matter, and then you can provide your policy advice later. They will be interested in your policy advice, but you really need to start with your legal advice. But how do you be sensitive to the client's needs and provide unsolicited advice, Christoph? Must come up in Germany as well. And this will be the last question. We'll end in about 2 minutes.
Well, John, that's a very good question, and actually you have already answered it basically. But it is important for lawyers to speak up. I mean, we are there to give advice, and very often it is unsolicited advice, and we have to give our clients, all the all the options, but also to to tell them where are the pitfalls, where are the dangers. That's our job, and we have meetings in the Foreign Office every day amongst the leadership. The head of the director generals and so on. We're meeting with the permanent secretaries every day, and we discuss. And I would put my hand up and say, look, there's another angle perhaps, but then once the decision is taken, of course, our job is also to defend that within, of course, certain ethical parameters. But in my 25 years or so in the Foreign Office, I've never luckily come into a situation where I had I had to say, well, this is not ethical anymore. I cannot defend this position.
Well, thank you. And I think that's the same for all of us. So we're all out of time. That in itself was something that we could all talk about, but we will have to leave it there. So I want to thank all three of you all. You're terrific public servants, great friends of mine. I hope Rich Visek will continue to be a friend of mine after I ask him a question about the International Criminal Court. But thank you to all of the members of L who are listening. You all are terrific public servants. To the former members of the Legal Advisor's Office, thank you all for your service. For those of you all, and I'm particularly proud of the members of L who go off and teach the next generation, thank you all as well. So thanks to the American Society, Kathy, Christoph, Rich, thanks for being with us and taking time. Take care. I hope we can all be together in person next year. Bye-bye.